Yes.
You asked for 278, 216, and it's Article 4, which sets the referendum period.
Thank you.
Picking up where I left off, we were looking at the final part of the judicial judgment and the creation of the general and specific donations provisions, starting at paragraph 80, page 36 of the core bundle. And just to pick up a passage right at the end of their judgment, paragraph 98, there is a recognition there by the divisional court that to a certain extent it does create something that is not entirely satisfactory. And they say there in that paragraph, if it be said that distinguishing between such general donations and specific donations is not fully satisfactory, it is, we consider, necessary in order to make the best sense possible of a statutory regime which, while setting a limit on donations as such, limits spending on campaign activities with the object of preventing any individual or body from using its wealth to gain disproportionate attention for its views. Pausing there, that's what the policy objective is. We say that is fully satisfied by the regime that Parliament did put in place, both for the reporting of donations, the reporting of expenditure, and the reporting of common plan expenses. And it wasn't necessary for them to create this distinction between general donations and specific donations, and then bring them in that way. But returning then to paragraph 82, you see there's a heading, travel and accommodation expenses, and what the divisional court was doing was working through general donations and specific donations, the dichotomy that they've created, with three related scenarios relating to the travel and accommodation expenses of volunteer campaigners for a permitted participant. And we see that worked through in those paragraphs 82 down to 90. And scenario A, which is referred to in paragraph 82, concerns volunteer campaigners who meet their own travel expenses and then are not reimbursed. And here, the effect of paragraph 2C in Schedule 13 excludes the expense from the definition of referendum expenses. So that example doesn't anywhere and is not relevant for present purposes. B and C are. And in scenario B, the volunteer campaigners meet their own travel expenses and are reimbursed by the campaign organisation, which the divisional court describes as a permitted participant. So paragraph 2C in Schedule 13 is inapplicable, and these constitute referendum expenses. So they do fall to be considered. That's scenario B. Scenario C, in the final sentence of paragraph 82, a permitted participant pays for the travel expenses of the volunteer campaigners. They are referendum expenses, and the divisional court says in paragraph 84 that this falls to be analysed in the same way as scenario B. So B and C, they say, go together. Now, in these scenarios, the volunteer campaigners are the equivalent of Mr. Grimes. The travel company is the equivalent, the hotel is the equivalent of AIQ, and the campaign organisation is the equivalent of Vote Leave. And we immediately see, it's the point picked up from Lord Justice Burnett, the difficulty here with the analogy. First, whereas Mr. Grimes was a permitted participant, the volunteer campaigners in scenarios A to C are not. They're merely affiliated with an organisation that is a permitted participant. Secondly, because the volunteer campaigners in scenarios A to C are not permitted participants, when they campaign for an outcome sought by a permitted participant, it's much easier to conclude that when they expend money, because they're not permitted participants themselves, they're doing so for and on behalf of the permitted participants. And the divisional court in paragraph 90 concludes that in both of the scenarios, B and C, it's plain that the campaign organisations incur expenses in bearing the cost of the travel and accommodation. So the campaign organisation, as I've noted, is the equivalent of Vote Leave. And the divisional court here appeared to require there to be an agreement to reimburse the volunteers, Mr. Grimes, on the basis that it was that agreement that would, quote, establish the requisite connection between the expenses and their subject matter to satisfy the second element of the definition of referendum expenses. So, in scenario B and scenario C, if the volunteer campaigners have decided for themselves to travel, let's say, from London to Birmingham, and it's not being done under any agreement or understanding with the permitted participant, then it's the volunteer campaigners who have made the transaction with the train company and the hotel to travel from London to Birmingham and stay there. It's the volunteer campaigners who have incurred the expense of that train fare and the hotel. And the fact that they are reimbursed by the voluntary organisation later on, that doesn't alter that fact. They have incurred it, and it doesn't suddenly change character according to whether or not subsequently they are reimbursed. And so too, in those two scenarios, if the permitted participant donates some money to the volunteer campaigners, but with no agreement or understanding as to how they spend it, and the volunteer campaigners decide for themselves they're going to spend it to travel from London to Birmingham as opposed to beer money, then it's the volunteer campaigners who've made the transaction with the train company to travel from London to Birmingham and the hotel to stay in Birmingham. And it's the volunteer campaigners who have incurred the expense of the train fare. But on the other hand, in those two scenarios, we just alter the facts. If the volunteer campaigners have decided to travel from London to Birmingham, but they're doing so pursuant to an agreement or understanding that the permitted participant is going to meet that expense or expenses, whether that particular one or expenses of that kind, and whether the campaigners have the money in advance to pay for the train fare or the hotel, or whether they're reimbursed later, they're incurring the expense on behalf of the permitted participant. That's how they get captured.
Well, these are all rather dense analogies, and I on this occasion, I have read ahead in your speaking note, and you come to the concluding submission that the scenarios relied upon are not particularly illuminating, and as to the extent that they were treated as analogous, they just confused the issue.
They did indeed.
So we've got the.
So then I turn to what we say in the Electoral, which is all very nice, of course, criticising the court below, but telling the court, well, what is the correct position? And we say it can be summarised with 7 points, and they're all, first of all, a body incurs an expense for the purposes of section 111 when that body brings that expense onto itself for itself. In other words, when the body does or gets something for which it met or must meet a consequential expense. Not in issue is point 2, that for the referendum, for the expense to be a referendum expense, it's got to be both an expense incurred in respect of one of the matters in paragraph 1 of Schedule 13 and not excluded, and be incurred for referendum purposes. That much is not in contention. Our third point is that where another person discharges the liability that a participant has incurred a referendum expense, that of itself does not alter the fact that that liability has been incurred by the permitted participant and only the permitted participant. And it will be under section 120A for the permitted participant and only the permitted participant to include that amount in its statement of payments. And again, the fact that someone discharges the liability is or is not a permitted participant doesn't alter that fact. Fourth proposition, or fourth point, is that the person who discharges the liability will have made a donation to a permitted participant, and again that's not contentious, and that of course is the subject of a separate report under section 119. If, on the other hand, point 5, the person incurring the liability does so for and on behalf of the permitted participant, then it will be for the permitted participant and only the permitted participant to include that in its subsection 2A statement. And the fact that the person incurring the liability is also the permitted participant doesn't alter that fact. Sixth point is that where the person discharging the liability does so pursuant to a common plan in the meaning of the 2015 Act, then that permitted participant must, in addition to its other statements of payments, prepare a separate declaration that identifies all of the other parties and all the other individuals or bodies in the common plan and what that common plan expense is. And that is what we say empties out the policy consideration which the Divisional Court refers to as having driven it to create what it recognised wasn't a fully satisfactory regime which it had created between general and specific donations. And then our final point is that in relation to a permitted participant that doesn't actually incur the referendum expense, is a party to the common plan, it has to make its own discrete declaration that that is the case. And with that regime, we are giving full meaning and operation to all of the provisions. It ensures there's no double counting within any of the various statements required by section 120. We're not giving unnatural meaning to the words incur expenses. We're giving full operation for the phrase for and on behalf of. It's consistent with other uses of the terminology in the 2000 Act and the 1983 Act. It's consistent with the only authority in the area, and it provides, very importantly, those who consult the registers to see how much has been donated for the various campaigners with a clear, unconfused statement of who has donated what, who has incurred what, and how much there was by way of common expenses. And in the reading note I've set out what the consequence of that is so far as this is concerned. The answer to it all, we say, is that Mr. Grimes, having made those 4 agreements, he had to include the 620,000 in his statement of payments made. He had to include the 620,000 in his statement of donations made to him. Vote Leave didn't need to include the 620,000 in its statement of all payments, and in fact, as has since been concluded, this was a common plan expense. Each of those parties had to put that in their declaration under section 124A and 4B. So that's the primary ground of appeal. We have a fallback position, and it is a fallback position because our preferred, I'll make it quite clear, our preferred ground to succeed on this appeal is the primary ground, because the fallback position leaves the Electoral Commission with a lot of difficulties in relation to the phrase expense curve, not just in relation to this particular provision, but all of the provisions in this Act and the RPA dealing with that phrase. But it's enough, the fallback position, for us to succeed in this appeal. And that is that even if the Divisional Court were correct to characterise the 620,000 payment by Vote Leave as expenses incurred by it, Vote Leave, we say that the payment was nevertheless not a referendum expense, because when you look at that payment from the perspective of Vote Leave, it's a payment incurred in respect of a donation to a permitted participant, Mr. Grimes, and not in respect of any of the matters that we see listed in Part 1 of Schedule 13. And the critical fact recorded by the Divisional Court in its judgment, paragraphs 15 down to 18, is that the 620,000 payment by Vote Leave constituted a donation by Mr. Grimes, no one doubts that. And the Divisional Court didn't like this argument when it was put before it. We see that in paragraph 28, and then they deal with it at 69 down to 72. And we say that the flaw in their reasoning is that the examples they give in paragraph 72 would all be expenses incurred by the payer on behalf of the permitted participant. That's the mistake that they are making. They're not seeing that it's not simply payments made by or expenses incurred by, it's also expenses incurred on behalf of a permitted participant. And in terms, payments by one person on behalf of a permitted participant are captured by section 111. It doesn't need to read in words into the Act. You don't need, we say, concepts of proximity. You don't need to puzzle over the meaning of the words in respect of. It's already there in section 111, subsection 2. All that one needs to ask is, did X incur a referendum expense on behalf of a permitted participant Y? The answer to that is yes, then it's captured. That's what on behalf of means. The Divisional Court didn't proceed on the footing that Vote Leave incurred the expense on behalf of Mr. Grimes. It characterised the payment, leaving the hands of Vote Payment as a referendum expense incurred by Vote Leave itself, albeit a referendum expense incurred by Mr. Grimes. And that presents many problems as it seeks to answer. One asks, for example, looking at it from the perspective of Vote Leave, was the expense, looking at it from the perspective of Vote Leave, in respect of any of the matters in Part 1 of Schedule 13? The answer is no. It was, so far as Mr. Grimes was concerned. Looking at it, standing in the shoes of Vote Leave, the expense it incurred was in respect of money donated to Mr. Grimes. From Mr. Grimes's perspective, it was incurred in respect of advertising, hence falls within Part 1 of Schedule 13. So we say, even if we fail on our primary argument, we should succeed on our secondary argument. That leaves a couple of mop-up points in the respondent's skeleton, which I've dealt with in my note, but I think in light of the time it might be worth hearing from the learned friend, giving a little bit of extra time, and then I can deal with those by way of reply, unless there are points that the court would like you to deal with.
Yes, because that will continue. That's what I thought. Yes.
Mr. Cottle, can you help me with one thing? I don't know if you've seen it, we've received a letter from Saunders Law, dated the 2nd of July.
2nd of July?
Yes.
I know I've not seen it.
I respect copy.
Yes.
Just check both of those behind me. Can I bear with me?
We'll hand
We
it
can
down.
give you a copy. If you have a look, if you don't mind, just have a look at the letter, and you may be able to assist us with what this is a reference to. We think we know.
And then let Miss Simon see it as well, because I don't think you've got
Have
a
you
copy.
seen it?
No.
No.
Right.
Let's share.
Yes, please.
It's a short letter, fortunately.
And it refers to a forthcoming appeal hearing scheduled to take place on the 15th of July.
Yeah, so I can assist you on this.
Yes, what's that about?
So, Vote Leave and Darren Grimes both appealed the Electoral Commission's findings of July 2018 that there had been working together a failure to declare an overspending. The report should now be in the authority.
In other words, the common plans.
The common plan issue.
That's what we thought.
Vote Leave is no longer appealing, it's pulled its appeal. But Darren Grimes is maintaining it.
Yes, well, we thought that was probably what was happening. Yes, thank you. Yes, well, Miss Simon.
Sort myself out a little bit. I'm starting rather on the back foot for the reason that the argument I've heard today is neither a ground of appeal nor anywhere in the skeleton arguments. And I have to say, over the lunchtime adjournment, I didn't have time to read in detail this note, but on a very quick skim, the primary argument now run is not a ground of appeal, and indeed the secondary argument that raises the question in respect of is not in terms a ground of appeal, although I concede that you may be able to put ground one into it. Now, I think I'd better start by just showing you that, because obviously it means that your lordships have not had the benefit of our argument on the question of incurring a referendum expense in writing, and nor have we had a chance to respond to anything that might have been made in a slightly different way from the way it was made below. So the core bundle, you'll find the grounds of appeal. They are in tab 1. And you'll see the grounds of appeal, page 13. The first ground is effectively that a donation cannot be an incurring of the referendum expense, because there are two regulatory regimes, not because of the definition of incurring a referendum expense. And the discussion about that definition formed a key part of the case below, and is not appealed before you. So I just want to...
Well, which paragraphs of the judgment do you say deal with that and are not subject to appeal or not relevant for purposes of the appeal?
Judgments about... I'm going to come to all the... Somewhere I've set out... Yeah, so it's from 36 onwards of the judgment.
Mm-hmm.
I want to find... So the grounds we have, if we then go to the skeleton, that's at tab 8, page 56.
This is the
The
appellant's.
skeleton, paragraphs 14. 15. We see that the appellant says the divisional court focused on the meaning to be given to the word incurred without addressing the logically prior question of whether within this statutory scheme a donor can incur referendum expenses at all. And that is the argument, the central argument that is made as their primary ground of appeal. And it's a different argument. And 15, in the appellant's submission, the payments in the present case are governed by the donations regime, not the expenses regime. Accordingly, they were not referendum expenses. That is the primary ground of appeal. And in our skeleton, if we go to the next tab, we see paragraphs 31 to 32. Before the divisional court, the argument principally revolved around the first criterion, the circumstances in which a person could be said to have incurred an expense. And then we set out what the position was before the divisional court, the Electoral Commission's position. And then we say at 32, this issue does not appear to be pursued by the Commission on appeal. Instead, the focus of its submission is the on the statutory language is now on the second criterion, i.e. whether or not the expense in question falls within Part 1 of Schedule 13.
Mm-hmm.
So is that a reference to what is now being called the secondary ground of appeal?
Well, unfortunately, the secondary ground is not quite
Oh, I see.
the way it's argued, because now in the secondary ground, the appellant is raising the question of what in respect of means,
Yes.
which again is not raised in the grounds or in the skeleton, and I had assumed was not in dispute. So we are slightly on the back foot in terms of dealing with it directly. We have our skeleton below, copies of it. If your lordship should decide, despite it not being a ground of appeal, to consider the argument, we would suggest that we hand up the skeleton below where we deal with the questions. Obviously, the argument is put in a very slightly different way, although we're still not quite clear what the Electoral Commission says incurred expense actually means.
Ms. Stanwell, can I just ask you about page 77 of the bundle, paragraphs 39 and following of your skeleton argument, where you sought to respond to ground 1
Exactly.
as formulated. But I may be missing something, I'm sorry, but I read paragraph 40 as being a direct response to exactly the kind of argument we've been hearing today.
Well, my lord, not as we understand the argument that's made today, because the argument that we understood was being made was that if you're in the donations regime, you don't get into the incurring expense regime. That's how we understood the argument. And so it was a sort of ouster.
But isn't that still what's being said?
What I understood was being said today was that there wasn't an incurring of an expense, which involves analysis of what the question of incur means, which was a major part of the discussion below, and on which there were authorities, and you'll see in the judgment. We talked about whether a donation can be an expense under the word incur an expense. That analysis of statutory language was not a ground of appeal as far as we understood it. We understood the position being put in the skeleton grounds that there is a donation regime and an expenses regime. And if you're in the donations regime, it is contrary to the purpose of legislation for you to look at the expenses regime.
That's certainly one of the arguments.
And I understood that to be the...
I don't know if my lord would mind. Can you just clarify that? Because I see Mr. Copper shaking his head. You're saying that's not one of your
No,
arguments.
my argument is this is my money in, money out point. There is a regime for money in, there is a regime for money out. Money can go in and be treated as a donation, it has to be reported. Money can go out, it has to be reported.
Yes.
And I have said quite clearly, and I think on more than one occasion, you can have the same amount going from A to B as a donation, and then B using it as a referendum expense. Same £620,000 in different hands. I thought I'd made that perfectly clear.
Well, yes, I think we're all talking about the same thing. So you've got some discrete points upon the approach of the divisional court, but your central argument is that this £620,000 was a donation, properly recorded as such, from Vote Leave, and it was an election expense incurred by Mr. Grimes and not Vote Leave, and the two are entirely separate. I've been no, am I there? So there's a look of some perplexion on all our faces, I suspect. And that is, as you may have overheard, that is ground 1.
Well, the way I understood the position being put was that if a donee is incurring an expense, you don't go on to look at whether a donor incurred the same expense because one regime houses the other. And that's a matter of policy. So the way
Ousting is a very perhaps
perhaps in the,
too emotive a legal term.
perhaps I shouldn't use that.
No, I'm not in any sense criticising you,
But they are mutually exclusive regimes.
and the key, as I've understood the submission, to satisfying the broad statutory scheme is in the common plan aspect of this, where, if appropriate, precisely what occurred in this case can be looked at through the prism of common plan, and then subsidiary arguments which particularly focus on the creation by the the divisional court of the general and specific donations.
Yes, well, it may be that I'm overcomplicating it, but it was a very different position in terms of the analysis. You start with asking the question, are you within section 111? Is an expense incurred?
But they,
And there was a big analysis as to whether Vote Leave incurred an expense in the meaning of incurred. And that has not been appealed in terms of what the meaning of incurred was. But perhaps, I mean, that's right, isn't it? Because we had a lot of...
well, I think Miss Seaman, we need really to get on with the argument.
Just as we understood it, their position was even if the section 111 test is met by Vote Leave in terms of the payment, because it is a donation, section 111 does not apply.
I don't think, I hope this helps in addressing the substance of the arguments. I don't think that really is the burden of the point you have to address. I think what you have to address is the submission that the Act does, when properly construed as a whole, create two distinct legal regimes, one which governs donations and the other which governs expenses incurred. And therefore, even if, not that if it falls within section 111, somehow that's ousted by some other provision. That's not what's being said. I think what's being said is that when properly construed, section 111 does not include this kind of scenario, even if it might as a matter of ordinary language, literally. And the reason why it doesn't is because you have to construe the Act as a whole. And what Parliament has in fact done is create two distinct, mutually exclusive regimes.
Thank you. Just quickly before I move on to the detail, in relation to the Schedule 15 point about working together, and I will take you through this in more detail. Of course, when we're looking at the statutory purpose of PERA, you have to look at that statute alone, because the joint working provisions came in 2015 in the EU Referendum Act. And what, I will take you through it in detail, what you have to analyse when looking at PERA is whether that analysis of the legislation can work without the 2015 working together provisions. So whether the statutory purpose can be met without the 2015 Act. So turning then, I'm going to start by just picking up on a few statutory points. The first, if I can take my lords to section 111. Which is at page 23 of your bundle. It's sorry, it is at page 141. So referendum expenses, we've looked at this, but we can just look at it again. In relation to a referendum to which the fund applies means expenses incurred by or on behalf of any individual or body which are expenses falling within Part 1 of Schedule 13 and incurred for referendum purposes. And then referendum purposes means in connection with the conduct or management of any campaign conducted with a view to promoting or procuring a particular outcome in relation to any question asked in the referendum, or otherwise in connection with promoting or procuring any such outcome. And then we have the definition of referendum campaign. And then if we go to Schedule 13, which is crucial, and we look at page 168, we see for the purposes of section 1112, the expenses falling within this part of the schedule are expenses incurred in respect of any matters set out in the following list. And then we have a list of activities, and this is important, that are, if you like, active activities forming part of the campaign. And then we see exclusions. Nothing to be taken as extending to any expenses in respect of any property, services or facilities, so far as they fall to be met by public funds. Any expense incurred in respect of remuneration or allowance payable to any member of staff, whether permanent or otherwise, of the campaign organiser. Any expenses incurred in respect of an individual by way of travelling expenses, or in providing his accommodation or other personal needs, to the extent that the expenses are paid by the individual from his own resources and are not reimbursed. So if you do reimburse somebody's expenses, they are referendum expenses. Now, in fact, in this referendum, each side, each designated campaign raised about 12 to 13 million. But of course their spending limit is 7. They could nevertheless spend 12 to 13 million because 5 million could be spent on the excluded activities, which are not referendum expenses. And of course some may not be spent. Some may be spent after the referendum period. And that is important because when we're talking about donations to a referendum campaign, the donor, if they just simply give money, cannot be sure, it was suggested that it was obvious if you give money it's going to be used for referendum expenses. Well, it isn't obvious because that money might well be used for staff costs.
Well, some of it will be. It'll all go
into a pot.
It'll all go into a bank account from which everything will be paid.
Exactly.
And that's
Exactly.
rather the point.
So, but what you cannot be sure of when you give money is that you are going to be giving that money for the specific purposes of one of the items listed in paragraph 1 of Schedule 13. And what the divisional court decided was that if you gave it on condition that it would be used for one of those purposes, and that there was an obligation to use it for one of those purposes, then that payment was caught. But of course, if you give £20,000 to a referendum campaign, you do not immediately become a permitted participant because you have not specified that that money shall be used in respect of referendum expenses as set out in paragraph 1, Schedule 13. And that's the crucial point. If, however, you were an individual who decided that you wanted a particular Facebook advertisement spread by the Vote Leave campaign, so you produce an advertisement and you pay for it, and you might pay £30,000 for that, and you say to Vote Leave, here is this advertisement, please distribute it, then you become a permitted participant because you are actively participating and spending money within the terms of section 111 and paragraph 1 of Schedule 13.
Would the same apply if you were to provide for free valuable services? I know there are some separate provisions which cover the calculation of that, but you own a printing company and you say to one of the permitted participants, don't worry, we'll print all your materials for free. That then is quantified for the purposes of the statutory regime, but it might, if it were more than £10,000, would that make the person should be a
Yes,
permitted?
yes, my lord, it would, and indeed the guidance from the Electoral Commission says that, and that is one of the reasons why so many businesses did not speak during the referendum or hold events during the referendum. Why, for example, you didn't get an economist from a bank going on television, because businesses were very concerned that they would pass that 10,000 threshold, for example, the cost of that member of staff on television, on Newsnight, whatever, why there weren't events held. And I put that relevant guidance at the back of the authorities bundle. I would like to check you've got the additional authorities. It's at tab 9.
Yes,
Yes. So that shows, that's why law firms didn't hold events, because they didn't want to get themselves into a situation where what they were contributing by, for example, inviting someone from Vote Leave to speak, they didn't want to contribute above the 10,000 threshold and become a permitted participant.
You've used that phrase several times, and I'm not sure I'm following this, that becoming a permitted participant.
Okay.
No, section 117, page 144. Seems to me, at least, this is the starting point, but actually, never mind being a permitted participant, the starting point is that you must not exceed £10,000 in total referendum expenses if you're an individual or body, right? You commit a criminal offence, subsection 2, unless, the last words of subsection 1, the individual or body is a permitted participant. It's not that you become a permitted, it's that unless you are one, you're committing a criminal offence.
Exactly, and I'm going to come on to that. It's my third point on the law, because there was, in fact, it was my next point. It was said by my learned friend, if you are a permitted participant, you've got to make declarations. You commit a criminal offence, she said, if you spend or contribute more than £10,000 in money or kind without registering as a permitted participant. So it's not that you choose to become a permitted participant. The law requires you to become a permitted participant if you engage either with resources or the kind of donations we're talking about above a level of £10,000.
Well, you say that's the issue that we have to decide in this case. That's the issue of statutory construction, whether a donation can be, within the meaning of the statute, also an expense incurred. Because what's said against you, as I understand it, is that if you go back to the primary provision, we have to construe 111 subsection 1, that one must not read that simply on its face and in isolation of the rest of the Act. So where it says expenses incurred by a body, which are expenses falling, the primary submission against you, as I understand it, is that even if that would, on the face of it, include something like what you're describing, where Vote Leave discharges the liability of Mr. Grimes, that when properly construed, the Act as a whole doesn't have that legal effect at all, because it's a donation to Mr. Grimes.
Well, my lord, we submit that the Divisional Court was right to take the normal meaning of the word, and indeed the normal meanings of the words, properly construed, actually achieve the statutory purpose, while my learned friend's submission undermines the statutory purpose, and I will make that submission very simply, because what it actually means is that there would effectively be no requirement to register above £10,000, an effective requirement, and indeed Vote Leave, when it hits £700,000 or before, could purchase goods and services worth millions, including Facebook ads, as long as it gives them away. And that totally undermines the intention of the legislation, which is that participants...
So if they purchased the advertising and then gave it away, you submit that Mr. Coppell's interpretation would mean that wouldn't be caught.
Yeah, well, I say that because that is the advice and the position that was taken by the Electoral Commission. No, it is the advice, and I will take you to the advice that the Electoral Commission gave vote leave, i.e. The Electoral Commission said to Vote Leave that it could donate goods and services, including banners and leaflets, which it had purchased and contracted for, without declaring those as its own expenses, provided there was no working together. So that was its explanation. I will take you to it.
Is that the one that's set out in the email?
Exactly. And that was the basis on which the case was argued as well. I mean, it's wrong to say that these assumed facts are what it was combined to. I will take you to that as well, because I'm going to hand you up a document that the Divisional Court had, which were the scenarios. Because actually we have no findings of fact here, for obvious reasons. So the court was looking at scenarios, and that's what it covers in paragraph 81 of its judgment. So the position of the Electoral Commission was that any individual, including a permitted participant or designated participant, can donate goods and services to another participant, or indeed perhaps not even a participant, and that would not be declarable as an expense or confined within the expenditure limits. So I just want to take you to the particular test that the Divisional Court set out for Section 111, which is in the core bundle judgment at page 23, paragraph 26. And in the middle of 26, the Divisional Court explains the test. It can be seen that this definition has three elements. One, expenses are incurred by or on behalf of an individual or body. That's the first question. Are expenses incurred? Second, those expenses must fall within Part 1, Schedule 13. I took you to those. And they must be set out in that list in paragraph 1. A list of matters is then set out which includes advertising of any nature, whatever medium used. And then the third element of the definition is that the expenses are incurred for referendum purposes, and that is, and I read you that from Section 111. Now, that is the, we explained and put that test also in our skeleton, and in our submission, that is the relevant test for the purposes of deciding whether you have to declare the expense and whether it falls within the expenditure limit. My second legal point concerns permitted participants. I've already touched on it. My learned friend kept saying that if you're a permitted participant, you have to count. We say that's the wrong way round. If you exceed 10,000 of expenses that fall under Section 111, you must register, otherwise you commit a criminal offence. And indeed, this is exactly what the Electoral Commission found in relation to B-League, and you'll find that in the authorities bundle in its findings, which is at tab 4, because what happened in this case is that Darren Grimes declared the 620,000, but it was incurred by B-League. And if we look at 1.19, B-League was never registered, so page 212, B-League was never registered with the Commission as a campaigner. Unregistered campaigners could only spend up to £10,000 on the referendum campaign, but Mr Grimes, acting on behalf of B-League, incurred spending of £675,000. All this spending took place after B-League met the criteria for registering as a campaigner. And then 121, the Commission is satisfied that Mr Grimes knew or reasonably believed to have known that B-League was a permitted participant, and therefore incurred referendum expenses and therefore Mr. Grimes committed an offence.
Is this the subject of an appeal?
Exactly. But it illustrates the legal point. It's not, you don't choose to be a permitted participant and then have to comply. You have to register. And then so if we take the homelessness example, if Mr. Bloggs, I'm just going to take the analogy for the purpose of this legislation, if Mr. Bloggs gives cash to a homeless person, without any indication or control as to how that money should be spent, that is simply giving away money. It is a donation. It has nothing. It has no control over it. If he says to the person, "I'll only give you this money if you buy a sandwich with it," then depending on, look at how the divisional court stated it, but they said there had to be some obligation, then that is likely to be incurring expense for the purposes of helping the homelessness person, if you like. If you actually take the homelessness person to the sandwich shop and buy the sandwich for him and give him the sandwich, then you also incur the expense for helping the homeless person. And that is exactly what happened here. There was no loss of control. Vote Leave, we know from the facts as now found by the Electoral Commission, it was only as a result of Vote Leave agreeing to pay the money, and I believe it may be in the judgment as well, that Darren Grimes could actually purchase the services.
But you accept, I think, implicit in that example, that the mere fact that money leaves my pocket and goes to a homeless person is not the incurring of an expense.
No, I accept that it is, I would submit that it's the incurring of an expense, but not for the purposes of helping the homeless person, if that was Schedule 13 of the Act. So the provision says...
So is that, let's move away.
Yes, perhaps it's not very
Yes,
helpful at a certain point.
A big charity.
Yes.
A big charity. And anybody might be moved to send them £100, and it just goes into the pot. So, is that incurring an expense?
Well, our submission below, again, it's not something we can hand you the skeleton, and I believe it's finding of the divisional court as well, is that if there is an just as my lord stated earlier, if there is a loss of revenue by the person, or how did we...
Is this the outflow of economic benefits?
Outflow of benefit, precisely. If that is the incurring of an expense in normal...
Well, is it?
Yes, and indeed, the donation, I think we looked at the Corporation Tax Act, a donation is the...
Yes, I would perhaps suggest that most people who are giving a £5 or £10 to a charity in a box don't really think of the tax acts, nor still less do they think of international accountancy standards and things of that sort. And speaking for myself, if I just give a few pounds to a charity, I would have thought that it's a very odd use of language to say that I've incurred an expense in giving away a few pounds to charity. I just don't think it's a use of English language that many people would recognise.
Our submission is that the divisional court is right.
Oh, I
But
understand
if there's
that.
an outflow of benefit, if you have £100, as my lord said, at the beginning of the week, and at the end of the week you've got 10, you have incurred expenses expenses of £90.
You might just have dropped it in the street
Well, you might have. Apart from,
by
apart
mistake.
from- if you have paid for something, even for the benefit of feeling good to have given to charity,
Yes.
you have incurred the expense of giving to charity.
I see.
That's it, is it?
So 36 to 39 is the judgment. Yes. So part of our problem here, and again it's slightly awkward to be arguing this without it having been laid out, but part of our problem here is that the Electoral Commission has never specifically said what it says incurring an expense means. And that is criticised by Lord Justice Leggatt at 36 to 39 of his judgment. But it may not matter in any respect, in any event, because we are in respect of.
Yes, I think what we've also got to remember that the environment in which this debate is occurring gives rise to a plethora of criminal offences which would end up, some of them, depending, being determined in magistrates' courts, and others being determined in Crown courts. And I really do wonder whether sensibly a jury could be directed by using the language of an outflow of economic benefit or something of that sort. It just doesn't seem to be. It doesn't seem to be a very realistic approach to a phrase that essentially has been in these statutes since, is it the 1840s? It's 150 years odd, isn't it?
Well, there hasn't, so far there has been no problem with it,
Yes.
as far as I know. The Divisional Court considered that very limited benefit could be obtained by looking at elections because of their obviously very different contexts. Here you've only got two sides.
Yes.
Um,
But incurring expenses by or on behalf of is a common phrase. So we have to have an interpretation of it that stands scrutiny for the purposes of the criminal law.
yes, my lord, and what is unfortunate in this case is that the Electoral Commission has not ever put one, and doesn't put one today. And indeed, if you look at paragraph 40 of the judgment, you see Lord Justice Singh saying, ultimately, the position of the Electoral Commission on what amounts to an expense incurred within the meaning of 111 appeared to offer little improvement on the well-known elephant test of I know one when I see one. And
That somehow, it's implicit in that paragraph that this is somehow a criticism to be made. But with respect to Lord Justice Leggatt and now Lord Justice Green, it's not unusual in our legal system for there to be concepts which are just words of the ordinary language, and they have to be applied to the facts of a given case. And we often entrust that function, for example, to a jury. And we often deprecate any further glosses on statutory language being put. So what's wrong with saying the statute says what it says, and whether it applies or not will depend on the facts?
that is why, in a sense, clarity is required. Because if there is a penal consequence, one must know what it means. Lord Justice Leggatt, with respect to him, did actually go through a very, very detailed analysis in the previous paragraphs as to why he said effectively it meant an outflow of benefit, that was the right way to characterise incurring an expense. As your Lordship said, in relation to giving £10 to a homeless person, that is the incurring of a cost or expense. What is difficult, and if you can face going through the grounds and everything that happened below, you'll see that there were various exchanges of, well, fine, but what does it mean? Where do you actually draw the line on this? And our submission is simply that the Divisional Court got this
Yes,
point
yes.
right.
But so far as the clarity point is concerned, and of course one understands that that's an important consideration in interpreting legislation, what Mr. Coppell says is that his interpretation of the Act gives perfect clarity, so that you know exactly who's going to be the person who's regarded as having incurred the expense, you know who's regarded as having made the donation, and never the twain shall meet.
Except that you avoid the actual words of the Act and you blow a hole in achieving its statutory objectives, which is to ensure that individual participants do not exceed their spending limits. So what the Nolan Committee, then the government decided, initially the Nolan Committee decided, advised that there should be no limits at all. There should be no limits on individual participants and there should be no limits on either side. The government then decided, no, we won't limit either side, so the overall aggregate expense on either side, but what we will limit is how much individuals or campaigns can spend. And the reason for doing that is to prevent a particular voice and a particularly rich personal campaign having a particularly powerful voice in the debate. So that must be the primary objective. And again, what Justice Leggatt sets it out. Again, we had all the documents below. You don't have them here. We can send them. Those policy papers. But that is the crucial policy. If it is the case that you can simply buy goods and services, give your leaflets to someone else, you could spend 20 million on Vote Leave leaflets and give them to another campaign group.
So this argument is it all flows from the fact that you have one permitted participant, who happens to be the biggest one, providing money to another. But surely we do have to think about this not only through the prism of the facts of this case. And so, I mean, I come back to I think you've answered the question that if Mr. Bloggs decided to send Mr. Grimes £620,000 and say, good luck to you, get on and spend it as you will. I know you're buying advertising and so on, but it's up to you what you spend it on. That's fine. But if Mr. Grimes says to him, well, it's actually more convenient for various reasons if you could just discharge some of the bills directly for £620,000, he should have registered, should I say, as a permitted participant with all the consequences. And it does have a look of form over substance.
Well, my lord, it's, as again the Divisional Court explains, it's not perfect. It's not perfect, but what is clear from the guidance given to you or I, the public, is that this is how the Electoral Commission saw it, and indeed I will take you some documents to show you that this is actually how participants understood it, which is that if you're a law firm and you give your building or floor of your building to a campaign, if that building over the time had a market value of £11,000, you would have to be a permitted participant. Same if you paid to rent a building for somebody, or a floor of a building. And that is simply to ensure that the individual voices are controlled and known. And perhaps it's a balance that was struck, and it may not be perfect, but it was the balance, we say, that the legislation struck. And that in our submission is supported by the third legal point, which is section 112, which I don't believe you were taken to, which is at page 140. And this is the notion of expenditure regime. So that if you are given services of a certain value, you must account for those. But equally, our submission would be that if those services are above a certain value, then they would the individual donor would have to register as a supporter.
And the analogue of this provision was, in respect of ordinary elections, was looked at in McKinley in the Supreme Court last year.
Yes, exactly. So turning then to some points were made about the travel analogy. I just want to take you to the relevant guidance on that. First of all, you will have seen already in paragraph 2 of Schedule 13 that if you don't have to account for a volunteer's travel expense unless you reimburse it, there is no requirement for you to have a contractual liability to reimburse it. If you pay for it, just by giving the volunteer money, then you incur a referendum expense. And at the back of the authorities bundle, you'll see the guidance in tab 7. And this is referred to in the judgment. At page 276, third paragraph down, you only need to include overhead or administrative costs for the activities whose costs count as referendum spending. For example, overhead or administrative costs associated with people's travel or accommodation, provided you don't reimburse them directly or pay for them. So I suppose the distinction is being drawn there of actually buying the travel ticket or giving them the money for the travel ticket. In either case, you must account for it. But you don't need to report it if you don't do that. If you do reimburse or pay directly for people's travel or accommodation costs, including hotel rooms, this will count as referendum spending. And then that's set out in more detail on the following page. So now just, those were the legal points. From the statute. Just as an introductory submission, our submission is that the Electoral Commission has worked backwards from what they would like the legislation to say, rather than looking at what it does say and considering whether that outcome actually accords with the statutory purpose. As for the reason why we are here today, the Electoral Commission has said that the case has an air of unreality because it proceeds on the assumption that the facts were not working together. Now it's crucial, my lords, that you understand that the position of the Electoral Commission has always been, until its finding in July 2018, that on the facts, as assumed, there was no working together. And that's why we're here. So if we go to the grounds, you see they are in tab 1 of the supplementary bundle. What actually happened in this case? And it's page 21 of it's the supplementary.
Yes.
You'll see, my lord, ground 1, and that is effectively the legal argument that was before us. We were saying that the advice given to Vote Leave, at that time we hadn't seen the advice, but we'd been told that Vote Leave had been told that they could give goods and services to other campaigns without accounting for the cost of it. So we challenged that as the incorrect legal interpretation of section 111. That was ground 1. But in round 2, we said, in any event, on the facts as found so far, there is working together. And you'll see that the facts as found so far are set out in 52 onwards.
And that's found by whom?
What happened was there was an investigation in September 2016 and the 17, and there were FOIA findings.
I see.
But those facts were found when they closed the investigation. So they found that Vote Leave had paid AIQ for services, and I'm going to take you to it, provided to Darren Grimes or Beanie. And they found that that was not working together. And we said that that was wrong. So on the assumed facts, there was working together. And we said that the court could still decide this ground, even though, as a result of the judicial review, and in particular round 4 of the judicial review, the Electoral Commission had reopened its investigation. And what the Commission Court said was, we don't need to look at ground 2, because actually they've reopened the investigation into whether there is working together. But we do need to look at ground 1, because even if there is working together, the question arises as to whether the advice that you can give goods and services to another campaign without declaring the cost is correct legally. So this case was essentially a public interest case, and we're here to assist the court for that reason. A public interest case to establish what is the correct legal position, and in particular, is the Electoral Commission right to say to participants in referendums, you can donate goods and services to other campaigns without declaring the cost of them. So that's why we're here. It's not an unreal situation. Of course, it was argued it would be academic. It was considered particularly important that the case be heard, because at that time there was a sense that there might indeed be an imminent another referendum. So, and if I can just then take you to the findings of the Electoral Commission, if we go to, if we go to page 79 of the second supplementary bundle.
Second?
Yeah, the
We
unagreed, the ones that we weren't,
Yes.
Helen couldn't let us put these documents in.
right, and that's different from the third supplementary
Well,
bundle,
it
isn't
isn't, though. I don't know where the third supplementary is come out.
It's the same.
it? Well, I thought it was the same.
It's been called the third. I got unagreed.
All right, well, look, I'll get the.
If you look at the green
We'll
bundle.
get the same one out.
Should we call it the
there's
green
no-
bundle?
The green bundle.
Green.
Yes.
So, my lords, if you look at page 79. Vote Leave state that they didn't consider the donation to have been working together for the following reasons. It was clear and had been explicitly found by the Electoral Commission that making a donation does not constitute joint campaigning. There was no collaboration. While there was an implicit expectation the funds would be used to promote a video, no conditions were imposed. There was no, nor had there ever been at that point, collaboration or agreement between Vote Leave and Beanie. And then the Commission goes on and analyses the relevant emails. And then the finding is at the end. So page 88. You've reviewed the information, you had all the emails at that time, all the evidence that is before Given the so I've reviewed, in light of the information, it's clear that Vote Leave and Mr. Grimes were campaigning for the same outcome in the referendum. However, it doesn't follow, nor is there evidence to support any assumption that the two campaigns were working together to a common plan, because that's the test, that there's a common plan. Given the profile of Aggregate IQ and the success it had, it's unsurprising that Vote Leave purchased the services from the company. Likewise, given the proximity and his knowledge of the successful, it's not unreasonable that Mr. Grimes chose to spend the donation to Vote Leave in the way he did. And so he came to the conclusion there was no working together. If we then go to, so it's now suggested that on the facts there was working together. If we go to the Electoral Commission's finding in relation to Veterans for Britain on working together, that is in the Authorities Bundle tab 5. Paragraphs 461 and 462. Now what happened in relation to Veterans for Britain is exactly the same in terms of our assumed facts as Darren Grimes. That is,
So which paragraph?
I'm sorry, it's page 234, paragraph 4.61.
Thank you.
What happened was that Veterans for Britain used AIQ, again at the same time, right at the end of the referendum period, and the Vote Leave paid its bill of £100,000. So it's exactly the same setup we're assuming, but the Electoral Commission found that that was not working together because there was no common plan. So what it's requiring is must be something in addition, which is indeed what the Divisional Court found, and is unsurprising because it comes in a subsequent act, 15 years after the Para Act of 2000. So working together is not a solution, it is an additional, wider requirement that was imposed to achieve a different purpose.
Simon, at some point, can you show us, I know there isn't a decision here which is under challenge. Usually judicial review lies in respect of a decision which is under challenge. And I understand that there can be cases where there's some kind of legal advice, for example, or guidance, which is the subject of challenge. But speaking for myself, it would be quite helpful to see what the statement of principle is, which you say is in error of law. Because there must be somewhere the Electoral Commission says that.
That was what was being challenged. What happened was that we were told, and it was out in the airwaves, if you like, that Vote Leave was saying, and you saw it there in those submissions, Vote Leave was saying, we have been told by the Electoral Commission we can donate goods and services. We didn't get any disclosure of that. Vote Leave then came to the hearing, and the day before the hearing produced the email which contains what we say is the relevant decision that we're challenging in round one. And I'll take you to that.
Please.
It's at, it is, I can take you through the chain that leads to this, but perhaps I can just start with.
By all means, but it'd be quite helpful at some point we can actually see the statement
Yes, okay, let's go to that
of
straight
erroneous
away,
law.
and then I'll take
The statement of erroneous law.
Yeah, I'll take you to these bits that lead to it.
Thank you.
So it's in the supplementary bundle, the unagreed
The green bundle.
supplementary bundle at page 10, I think.
So green bundle, page 10.
Page 10.
Thank you.
And the reason I'm going to have to take you back is because it is in response to the question, so you need to see the question. So the statement is at the top of page 10. If you are supplying material to other campaigners without having a coordinated plan or agreement, then the material is likely to be a donation from you to the other campaigner. If the donation is over £500, it will be reportable by the other campaigner. You would not need to report the cost of the material in your spending return unless you use the material. So the test was use. If you use the leaflets, as in you go around and hand them out, I mean, it's not very good work because, but I assume that's what it meant. If you hand out the leaflets, you have to account for it. But if you give it to Darren Grimes to hand out, and he uses it, then you don't have to account for it. And I can take you to the prior question.
Yes, certainly, but just can I plant this thought? The issue that the Divisional Court actually decided is set out in paragraph 1 of its judgment, and it's concerned with the, I can put it this way, the direct payment by Vote Leave of the bills for the advertising, as compared, as it turns out, with just giving the money and letting Mr. Grimes do what he wants with it. There's no discussion, is there, in the judgment about leaflets and things of that sort?
No, my lord, although there is discussion about donation of goods and services, I presume. But there is a... that has a slight history too, because if as always to get to appeals, that was the ground of judicial review that was incorrect legal advice. The legal advice then came just the day before the commission hearing. Not legal advice, sorry, advice from the Electoral Commission.
Yes.
The skeletons then proceeded in a normal way of judicial review to challenge that advice. But the Divisional Court was resistant to approaching what it considered theoretical. So as my Lord Justice Singh states, we approached it on the basis that that was the issue to be decided, whether this advice was right. But the Divisional Court resisted that, was not happy to do it in that way, and wanted to pin it down to the facts. But what did happen, and what was used for the Divisional Court, was a set of assumed facts. And I've given it, and they were below, and I've given them to my learned friend, because of course he wasn't representing the Electoral Commission below. And I will hand them up to you, because these were assumed facts that we put, because the Divisional Court was so insistent that we look at facts rather than the decision.
So were these agreed assumed facts? Or?
They were assumed facts that were used in the hearings. It was not, they are hypotheticals.
Oh, I see.
They're hypotheticals. But the ground one, you'll see in the grounds and in the skeletons.
Yes.
So, my Lord, if I can just take you back to what ground one actually challenges, but as I said, we didn't have the disclosure until Vote Leave gave it to us the day before the commission hearing. But if my Lord looks at page 8,
Oh, in the green bundle still. Yeah.
you'll see what I just showed you, what it was a response to. Yeah, so there's one before. Yeah, we actually need to start with the 29 April bundle, which was not put as an exhibit.
I'm just looking at I mean, Miss Simon, this background is obviously of some interest, but this is an appeal from the order made by the Divisional Court, which we find at page 14 of the core bundle, the material parts of which application for judicial review granted and a declaration is made on the proper interpretation of the definition of referendum expenses in section 111.2 the 3 payments totalling 620,000 made by Vote Leave, etc., were referendum expenses incurred by Vote Leave. So we're not here
Well,
to conduct a sort of general
No,
debate about
I
other things that were
completely-
not the subject matter of argument below
yes,
and the
Michael,
order below.
I'm completely aware of that. It's slightly tricky because, in fact, when we got to the end of the hearing, the parties agreed the declaration. And again, I have that there. The declaration is effectively, that we agreed, was effectively paragraph 81 of the judgment.
Yes.
And that was the agreed declaration that we sent up to the court.
And is that the one then they didn't like and they wanted to set
Exactly.
their own?
And we have copies of it, the ones that we agreed.
We do have, well, we do a transcript of that short
yes.
hearing, yes.
Was there actually a hearing? I'm not sure there was a hearing. I
Yes,
think
we have a
there's a
document.
judgment.
You've
A
certainly got a
judgment,
judgment,
There
yes.
wasn't a hearing.
I'm sorry, my apologies, it was a judgment.
But we do have copies of the declaration agreed, which effectively copied out, and indeed written by the Electoral Commission. So it set out paragraph 81. So all the parties were content to proceed with this on the basis that it was a public interest case, deciding the law in order that the Electoral Commission would apply the law correctly. The Divisional Court was not content to proceed in that way and wanted to pin it down to the facts, and that was also reflected in its declaration. But in any event, we are in a position where the crucial point for public interest purposes is the judgment correct as to how it analyses donations, because it is purely academic in relation to Vote Leave, because Vote Leave have been found to be working together, and therefore in any event they had to bear the cost, it had to be part of their expenses that they gave to Darren Grimes
Yes.
under the section 22 provision.
And they've abandoned their
And they've
appeal.
abandoned their appeal. So
Yep.
this case is entirely academic insofar as it relates to Vote Leave. We are only here to assist the Electoral Commission should there be another referendum, so that it gets it right. So that is what is important in my submission.
Yes. And we're interrupting you so much, I do apologise
No,
for
no,
that.
not at
But
all. But
it may be that this now answers a question that I didn't think I was going to ask, but the issue to be determined in this appeal at tab 7 of the core bundle was agreed between the appellant and, it would appear, Vote Leave, I think.
Yes.
But the first respondent's position, and that's for these purposes you were unable to agree the formulation, or
yes,
so it said. But is that question in fact wrong, given the terms of the declaration made by the Divisional Court?
I believe it has an additional word in it, which is liability, which is not in the declaration by
I
the
see.
Divisional Court.
Okay.
And there is no evidence, there are documents about what are called insert orders, but there is no actual evidence or finding either by the Electoral Commission in its recent report, or insofar as the Divisional Court could have found facts, that there was any clear contractual liability. So had Darren Grimes not been paid, AIQ could have sued him. That is, there are various assumptions as to whether, indeed below, the Electoral Commission were not saying that that was part of the requirement. A question which is being raised repeatedly now is that in relation to events which Vote Leave has not organised, is not involved in any way in coordinating, but for which it is requested to provide branded materials, such as banners and flags. We provided an example previously in relation to the flotilla, and that's the traditional document I just handed out to you. Other examples are events organised by the university groups where we're asked to provide speakers or branded material. Where this is the case and we do so, we're treating these events as independent events and not campaign events, on the basis that we have not coordinated, organised, collaborated in relation to the event. Your guidance already accepts that the mere provision of a speaker does not convert something into a Vote Leave event. And then interestingly, it says the cost of any materials provided would be treated as campaign expenditure in any event, but the mere provision of such materials to a third party does not in itself constitute working together. So what Vote Leave were concerned about was not the cost of the materials, but that if they gave the materials, that would give rise to a working together situation, the consequence of which would be that it would have to bear the entirety of the expenses of the whole event. So that was what it was concerned with. But the response which it received, and on which it relies to say that actually it didn't have to account for the banners, flags, leaflets, is the document that I showed you at page 10. So the Electoral Commission doesn't write back and say, you're quite right, you must account for the material. It says the opposite, which is you do not have to account for the expenditure on that material. And that was what we were challenging as wrong, and indeed is not in any of its guidance, and was not understood by other parties in the referendum to be the case, but is quite explicit here.
So just help me with exactly where in the
That's
letter that
page
is.
10.
Which,
So if you are supplying material to other campaigners
yes.
without working together, then it will be a donation. It will be reportable by the campaigner. You would not need to report the cost of the material in your spending return unless you use the material yourself.
Yes.
So on that basis, they said, well, we can give Facebook ads, we can give materials, we can give goods, flotillas, banners, provided we are not working together. We do not have to account for the cost.
The problem is that this is not the issue that the Divisional Court dealt with at all.
Well, it is, in the sense that the position taken by the Electoral Commission below, and as I understand it today, is that that is correct. That you can, as an individual or a committed participant, donate goods and services to another campaign. Wherever the contractual access lies, you don't have to be contractually liable to pay it. You can do that, and you do not have to account for the cost of it.
Miss Lowe, you may be right in having that understanding, but certainly speaking for my part, I didn't hear any submissions this morning from Mr. Cock along those lines. What we heard were submissions about donations of money, as I understood it, and a pure question of statutory construction. Now, as my lord has already observed, this court is not sitting as a court of original jurisdiction hearing the claim for judicial review. It is sitting on appeal. Appeals only lie against orders, and we've seen the order made by the Divisional Court, and in particular the terms of its declaration. So that's what we're concerned with.
Yes,
I'm afraid we don't sit to give general advice, however much the Electoral Commission might value it, or others might value it, because we usually decide cases which arise because it's necessary to decide them on the facts, which generate a legal dispute. But sometimes, depending on the circumstances, we might give some more general guidance on an important point of legal principle. But I have to say, speaking only for myself, that the more I have heard, the more anxious I become that actually this isn't a pure question of legal principle, that it may well turn on the facts of particular cases, and a close analysis of those facts might be required.
Well, my lord, the position taken by the Electoral Commission below, and as I understand it, it's not been altered today, and certainly there was no suggestion by the Electoral Commission, on the contrary, that there had to be a contractual liability by the donor to purchase the goods in order for it not to be donation. So,
All right. Well, just following this point through, just whatever we are able to make of it. We're looking at a paragraph in an email exchange at the moment. Was the substance of that paragraph put into guidance available to all those involved?
No. That's
So-
the problem, indeed on the contrary. That's one of the problems.
Yes.
The Electoral Commission has never resiled from this. It has never said that was wrong. On the contrary, in all its documents and its defence and its skeletons, we may have to get you the skeletons below, its position was that it defended that. But the assumed facts that the court looked at are the ones that I've handed up to you. And the other point that perhaps I can give you, I can take you to, is that the factual finding by the Electoral Commission was not that Vote Leave had donated money. It was that Vote Leave had donated services to Darren Grimes. And I need to find the reference to that.
Yes. All right. Well, but this is not an appeal to factual findings by the Electoral Commission. No, I mean, Miss.
The reason this is important is because
Now look, Ms. Simon, we've really got to focus on the submissions that you wish to make to deal with the order made by the Divisional Court and the challenge to its legal conclusions. And when one looks at the judgment, I've already referred to the first paragraph, which identifies the issue that the Divisional Court itself suggested it was determining. And then between paragraphs 12 and 20, we have the factual premises upon which the Divisional Court then proceeded to determine the legal issue. And those really provide the four corners of the scope for argument. And I appreciate, as my Lord has said, that there may be all sorts of concerns about what's in an email and how the Electoral Commission may view other matters that weren't actually considered by the Divisional Court. But I'm afraid we are concerned only with the order made by the Divisional Court. We've heard the arguments advanced by Mr. Coppell to support the appeal, and we must confine this appeal to that.
My Lord, I appreciate that, and the reason I took you to that is because that was the decision that was being challenged originally. That was the actual decision in ground one that is challenged. And we ended up in a situation where the assumed facts as set out by the Divisional Court are as they are, and I appreciate that that's what we need to stay within. That said, it is in my submission relevant that the Electoral Commission corrected and decided not to bring charges against Darren Grimes because both Darren Grimes and Veterans for Britain declared receipt of a cash donation.
Just forgive me. This is all interesting but peripheral, and with the greatest of respect, Miss Simon, we're here to determine an appeal and to hear the submissions that you wish to make on behalf of the Good Law Project to resist the appeal. And I've just got an uncomfortable feeling that we're straying very widely into all sorts of areas which enable points to be ventilated, which have nothing whatsoever to do with this appeal. And you've just indicated the decision under challenge. In the judicial review claim form, the decision under challenge is identified as the failure to investigate and to take action in respect of the spending of Vote Leave Ltd and the other campaigners in the period leading up to the 2016 referendum. So it's a rather general challenge, and then it's dealt with rather more thoroughly in the statement of facts and grounds. But the divisional court, I don't recollect even setting out that email exchange. It didn't set out that email exchange, still less think that it was a challenge to a decision of an expression of view in an email from an official.
Right, as I said, it was not the centre of the case, not because we didn't argue that was the decision, but because they wanted to pin it down to facts. And
Yes,
I totally appreciate that we are on appeal from that one. The reason I raised the fact that the Electoral Commission says that services are donated and that Darren Grimes and Veterans for Britain breached the law in declaring a cash donation, because those are the findings, we'll give you the reference. So Darren Grimes declared cash and Veterans for Britain declared cash. The Electoral Commission corrected that and said that services were donated because the payment had been made to AIQ. So the question that is directly relevant to the question before your lordships, which is the donation of services to another participant, is the donation of services to another participant incurring an expense?
Well, that's another variation on a theme. Ordinarily, one would possibly imagine that to say X has donated services to Y would encompass X lending an employee to Y, or providing legal or accountancy services.
No, but the reason...
Paying someone else's bill is not in ordinary language
But for
providing
the purposes,
services.
But for the purposes of the Electoral Commission, what it said, and we will find the references for it, is that because Vote Leave paid for the services,
Yes.
it donated the services from AIQ, it donated services. And Darren Grimes and Veterans for Britain had breached electoral law in declaring a cash donation. Yes. It follows from that the Electoral Commission is saying, in accordance with that mail, that you can donate services and goods to another campaign,
Well,
irrespective of the
we have the point,
yes.
but we haven't very much time left,
No,
Miss Simer, and I think we really do need to get to the heart of your submissions in response to Mr.
Yes.
Topple.
So, in assessing the correctness of the declaration, of course, my lords have to analyse the Act and advance an interpretation that is coherent with the whole Act. And in that sense, it's relevant to consider the various possibilities, and that is how the Divisional Court proceeded. Now, on the primary position put by my learned friend, which is that if there is a donation, it cannot also be an expense, it says this for two reasons in its skeleton. Paragraph 12, it said that nothing in Schedule 13, paragraph 1, provides for a donation to be a referendum expense. So it says that the working of para is consistent with a payment by way of a donation, never amounting to the incurring of a referendum expense. And it says this because Part 1, or Paragraph 1, Schedule 13, doesn't include the word donations, and that's in Paragraph 12 of its skeleton. And then it says it would be detrimental to read the legislation to allow a donation, a payment in respect of a donation as falling within Paragraph 1 of Schedule 13, because you'd end up with double counting. That's essentially the argument as we understand it. And that it was wrong for the Divisional Court to focus on the question of incurred, and it says that at Paragraph 14 of its skeleton. As I've said, we say that it does not actually challenge the analysis of the word incur by the Divisional Court. we adopt in relation to that point the findings of the Divisional Court at 55 to 64, and we make the following points. First, the Electoral Commission doesn't and cannot say that the legislation precludes a donor from incurring referendum expenses, nor can it say that the legislation prevents the regimes that govern the declaration of expenses and donations covering the same sum of money. All it can say is that its interpretation is consistent with the scheme. But as the Divisional Court pointed out, had Parliament wanted one regime to preclude another, it would have said so, and that's at the end of paragraph 58 of its judgment. We say it didn't say so, and there's no reason as a matter of policy why it should. Secondly, the Electoral Commission's approach begs the question as to why one should, under the legislation, ask first whether something's a donation, rather than whether something is the incurring of a referendum expense. And the Electoral Commission does not explain why the donation regime should come first. And we say there's nothing in the legislation to suggest that one regime precedes another in the analysis of any payment. Thirdly, as to the Electoral Commission's argument in paragraph 12, that a donation could only be a referendum expense if the word donation was actually in paragraph 1 of Schedule 13. This, in our submission, ignores the fundamental question of whether the expense is incurred in respect of one of those matters. And I took you to that paragraph for that particular reason. If you are giving money to pay in respect of a particular matter, you fall within paragraph 1 of Schedule 13. So if the donation is in respect of one of those matters, you fall within it. And indeed, this is the point I just said, but I'll go through it very quickly. The Electoral Commission has correctly found that the services purchased were matters that fell within paragraph 1 of 13. It finds this in its assessment review, which is in the supplementary bundle at tab 9, the unaggrieved. It's page 90. Page 94, paragraphs 19 to 20. It is clear beyond any doubt, page 94, clear beyond any doubt that payments made by Vote Leave to AIQ constituted referendum expenses. But the question of incurred is in 20. The Commission is satisfied that there was sufficient evidence gathered during the original assessments to indicate that services from AIQ were being procured by Mr. Grimes for use in respect of his campaign. It ought to be stressed that the fact that Vote Leave paid for these services does not necessarily mean that it was Vote Leave that incurred the expenses. For the reasons set out above and the wording of Schedule 15 to paragraph 2.1c puts this beyond doubt. So its position was as argued here. If it's a donation, then it's not incurred by Vote Leave, even though Vote Leave paid for those services. And the crucial words they use are being procured by Mr. Grimes for use in respect of the campaign. It was not argued by the Electoral Commission that there was a contractual test or a liability test.
And that's November 2017, isn't
Yes,
it? That
this is the
document? Yeah.
point at which they reopen the investigation in response to the judicial review.
Yeah.
And that was also in its summary grounds in the oral commission. The Electoral Commission accepted that the cost of AIQ services constituted referendum expenses. The only question is who incurred them. And then, as I already said, but I can give you the reference now, the Electoral Commission had found that Vote Leave had donated services, not cash, and actually his work going back while we're here, it's page 67 and 68, the same bundle. This is an investigation in September 17, I believe, and you'll see in the last two bullets,
So page 68 and 60.
67, Mr. Grimes reported the above listed donations as monetary donations rather than as non-cash, and providing the nature of the donations. Mr. Grimes voluntarily provided information which is sufficient to conclude that donations were in fact paid directly to a supplier who in turn provided Mr. Grimes with a digital marketing service. This is the donation of his service. And then the next page, second paragraph down, Mr. Grimes has provided sufficient information to conclude that the donations he reported receiving were donations for service, digital marketing, provided by ARQ and paid for directly by Vote Leave. And Mr. Grimes reported these donations as cash and didn't declare the nature of the donations, and that of course failed to comply, but they didn't think it was in the public interest to pursue that. And it does exactly the same in its July 2018 report in relation to Veterans for Britain, where Veterans for Britain also declared a cash donation, but in fact there was a donation of services.
They're not an interested party in this case at all.
They were, yes, they were. We did put them.
No, in this appeal.
They didn't want to take any part.
I see.
They didn't take part in the provision for either, but we did.
Right.
We did put them as interested parties. So the question then arises as to whether Vote Leave incurred those expenses, including whether its payment was in respect of them. And we say that the Electoral Commission has not raised either of these as grounds of appeal, and they therefore accept the Divisional Court's findings of 36 to 54 of the judgment in relation to incur, and 68 to 72 in relation to in respect of.
Sorry, which paragraphs?
Paragraphs 36 to 54 of the judgment
Yes.
for incur, and 68 to 72 in relation to in respect of, and in particular paragraph 72. So in our submission it follows that provided the court is satisfied that the services at issue were services within the categories of paragraph 1, schedule 13, as the Electoral Commission found beyond doubt, the Electoral Commission does not dispute that Vote Leave incurred expenses in respect of them. And that is because our understanding of the ground 1 appeal was that because donation is not listed as one of the categories, that we, there was no incurring of an electoral expense. Now we say that the correct approach to the legislation is as set out in paragraph 29 of our skeleton, and the analysis of the court at paragraphs 80 to 81 of its judgment is correct. And in our submission, the Electoral Commission has simply ignored paragraph 32 of our skeleton argument, where we accept what we say is the position, what we say is the position. And that is in core bundle at page 75.
As you've drawn our attention to paragraph 80 and 81 of the judgment, where the court is considering the distinction between general and specific donations, can I go back to the point raised by my Lord Chief Justice, that we cannot forget the context of this legislation and the importance of the man and woman on the ground and the possible penalties that can be incurred, which are criminal penalties. How does this concept of general and specific donations, which is another layer which isn't identified in the legislation, assist anyone on the ground understanding it?
So, my lady will have seen from the judgment that Lord Justice Leggatt is not entirely satisfied with this route through. And indeed, in the court below, we struggled to find a route through this we recognise that it cannot be right that a mere cash donation was intended to be covered. Because in a way it would be simple if there was simply a statutory limit on the value of donations, or if we knew that then you could give 10,000 and that was it. Everybody would know. But there is no statutory limit. And we all agreed that it cannot be the case that if you give 20,000 you become a permitted participant and you breach the law if you don't. So the way that the court found through this to both meet the objective of ensuring that individual participants stayed under their expenditure limits and allowing individuals to donate more than 10,000 without becoming permitted participants was to lay out a test that the court did at 80 to 81, and indeed requiring that there be some kind of obligation to use that money for a particular purpose, a legal obligation. And perhaps we can go to the judgment because Mr. Cleves points out that the general or specific is to deal with the language of in respect of. Specific meaning in respect of. General meaning not in respect of anything.
So you're saying that a reading of the legislation would lead someone to that understanding?
Yes, there is guidance from the Electoral Commission, and in fact this does happen. That people, I know of people who this has happened to, where they, for example, make a film for someone, and then they find that the market value of that film, that what they did professionally was above 10,000, and therefore they should have declared themselves. And there are, you'll see, very, very many people. I believe you said that 600 or so permitted participants. 123.
63 on the other side.
So, and if you look at the guidance from the Electoral Commission to people, it's telling you to be careful. So there is a problem with it, but the Divisional Court saw the only way out, essentially to put some kind of legal certainty on it, and I believe it actually thought the rule, or the way it had approached it, might even be insufficiently strict to reflect what the legislation actually said. Point about legal certainty. So 8 to 81. 81 is essentially the text. But I take my lady's point, and it was something that was debated at length below. There is no perfect answer to protect someone from making a mistake and potentially committing a criminal offence.
In relation to the question of obligation, the court earlier, paragraph 78, appears to suggest that it need not even be contractual. It could be an equitable obligation arising under a specific purpose trust.
It says equitable as well.
That's what I mean. That's exactly what I'm reading. Or it could be an equitable obligation arising under a specific purpose trust of the type recognised in disclosed investments. Now, I wonder how many people on the Clapham Omnibus will be familiar with those sorts of concepts.
Well, they probably wouldn't set one up. I mean, that's also they wouldn't actually. Well, it's it's a search essentially for a coherent interpretation of in respect of. That is essentially what the divisional court is doing. So I was at 32 of my skeleton. Perhaps you could just sideline it because we are obviously I'm running short on my opinion what we're doing. And then 36 to 37 of our skeleton.
Yes.
The ground two is the point that it would be detrimental to transparency, and this is also run as a justification for their interpretation of the legislation in ground one. So it's paragraphs 18 to 19 of their skeleton and paragraph 4. So they say that there would be a declaration effectively of 1.24 million when only 662,000 had been spent. And they say this would result in a mistaken impression by the public. We say, well, essentially we adopt the findings of the Divisional Court in 62 and 64 of the judgment. We say that the regimes look at transactions from different points of view, and that the aim of the legislation is not to monitor or measure the spending on either side. The legislator decided not to control expenditure on either side, but only of participants. And we set that out in 47 to 54 of our statements. The legislation only provides for the Electoral Commission to make spending returns available. It doesn't require the Electoral Commission to make aggregated data available. In any event, in certain circumstances there is double reporting provided for by Parliament in relation to working together in the 2015 legislation. Indeed, if you have, say, 4 permitted participants working together, each one of them must declare the entirety of that cost. And so you would get quadrupling of the expenditure in such circumstances, and that was not considered a problem. And as we explain in 50.31 to 50.33 of our skeleton, it is possible to disaggregate the data if you were really, really interested, and we explain how that can be done. More fundamentally, the Electoral Commission said this morning that it is problematic to have this double counting because it means that someone's spending limits are absorbed when they haven't really spent. And it says that a false figure is produced. We say that both are wrong and it's not problematic. First of all, if Vote Leave buys Facebook ads through AIQ and gives them to another Leave campaigner, it is using its money to procure the same referendum outcome, i.e. precisely what Section 111 provides for. And therefore it's right that in using that money to procure that outcome, it should stay within its spending limit. The interpretation given by the Commission means that it can hit its limit, and then it can say, well, we've got a couple of million over, we'll carry on spending with AIQ, but we'll give it to Darren Grimes, which is exactly what they did, and which the Electoral Commission record. They record that as a reasonable approach in their initial. They say it's perfectly sensible. So page 80 of the supplementary bundle, the unagreed one. It seems reasonable that an organisation finding itself with money it cannot spend would want to donate it to a like-minded group. Although Darren Grimes might be low profile, the organisation he chairs was running an online campaign prior to receiving donations, was known to Vote Leave. It seems reasonable for Vote Leave to consider that an online campaign would be an effective way to spend such a large amount of money in such a short period of time. you say, look, this person's running an online campaign, we like their campaign, we've looked at it, we're going to pay AIQ for another 650,000 for you to carry on doing that. That's exactly the same referendum result that it's procuring. So why shouldn't it have to declare that? So it's not a problem that it absorbs some of its limits, it's its purpose. And secondly, it's not a false figure, because both Vote Leave and Darren Crimes or Be Leave do spend that money on that purpose, which is what the legislation is supposed to catch. And then it says in ground 3, there's no basis for distinguishing between general and specific donations. The Electoral Commission recognises that its own interpretation does potentially undermine the purpose of spending limits, namely to ensure that one party doesn't have a larger voice than its limit allows. But it says that the Court of Appeal was wrong to approach it on the general and specific. It says rather that the approach to address is its approach on sham donations. And if we can go to paragraph 24 of their skeleton, they say there, in the middle, the appellant considers that the problem can adequately be addressed, sorry, it's page 59 of the book, can adequately be addressed by the appellant's existing approach to what it calls sham donations, i.e. where a campaigner purports to donate money to another campaigner, but on an objective view, expenses were in fact incurred by or on behalf of campaigner A. Now, it's completely unclear in our submission what this means and what the policy is, and how indeed it's any different from the approach stated by the divisional court. How is it different to the working together rules? And indeed, has it ever been applied? It says that this would be a cap on donations. We say that's not right. It's a cap on expenditure. Vote Leave could have given cash without any strings attached to Darren Grimes. So it could have said, we've got an extra 2 million, it could have given it away. They say it's unenforceable in practice, but the Divisional Court has explained in 79 why it has set out a test of sufficient stringency to produce legal certainty. And then ground 4 is that it somehow affects political campaigning, adds to regulatory burdens and discourages donations. At paragraph 33, it says that in relation to candidates' elections, the Divisional Court was wrong to say that the problem is avoided because all expenses must be paid through an agent. But it is clear from section 73(1) of the RPA, which is at page 12, that there is such a prohibition. Schedule 2A is there to ensure that where the prohibition is breached, the payment still constitutes a donation. Ground 5, it says that the Electoral Commission said their analysis the Divisional Court's analysis leads to surprising results. We've dealt with this at paragraph 63 of our skeleton, and I've asked you, I believe, to sideline paragraphs 36. Sorry, there is an oddity that the Electoral Commission at paragraphs 36(2) and 36(3) of their skeleton suggests that there is a common plan here on the basis of the assumed facts. And we don't understand that for the reasons stated, which is that they actually found that it was not a common plan, and they contested ground 2, which were the assumed facts, where we said there was a common plan, and indeed the legislation requires something more. If you look at section 22, you'll see what a common plan requires. And as I've already said, the position on Veterans for Britain is exactly the same as the assumed facts. But the Electoral Commission has found that that was not working together on common plan in their July 2018 report. Because they've said there isn't other evidence that there was some plan. I've already mentioned that the divisional court was clear that the 2015 common plan provisions in paragraph 22 of Schedule 1 were additional, and that's 91 and 92. So, my Lord, this one. Yes, there is just perhaps a closing important point, which is that what we're concerned with here is individuals or organisations that are controlling the expenditure. So there is a question of control. Who decides what this money is spent on? If you actually decide whether through a legal or an equitable obligation as set out by the divisional court, that this money will be spent on a particular advert, you have incurred expenses in respect of a referendum as set out in section 111 of Schedule 13. And that is actually what the Act intends in order to ensure you're in the spending limit.
Yes. Well, thank you very much
Sorry,
indeed.
I went on that.
No, please don't apologise. Mr. Coppell.
Just 5 points, which I can deal with very quickly. First of all, it was submitted at the outset that if A gives, let's say, £30,000 to B, the permitted participant, to be spent for specific referendum purposes or expenses, A becomes a permitted participant. So embodied in that is the mere making of certain payments renders a person a permitted participant. And that...
Well, it renders him liable to penalty if he isn't one.
Yes,
is what
and
you
that
mean,
is
yes.
simply and utterly wrong, and is demonstrable from the legislation. Section 105, subsection 1 in the Authorities Bundle, page 138, makes it clear that if you are not a registered party, to become a permitted participant, you must give notification. You don't become one by making a donation. To become a permitted participant, if you're not a registered party, you've got to give a notification. And the notification that must be given is spelled out in section 106. You have to give all of the various details. You do not become a permitted participant by the making of a payment. And there is, if I may say so, a complete confusion of thought by the respondent as to the distinction between a donor and a permitted participant. Anyone can become a donor, whether for £5 or £500,000. As a donor per se, one does not need to register or give notification. If you want to be a permitted participant, you must give notification, you must give the details, and from that notification, all of the benefits and burdens that are conferred and that are imposed by Part 7 of 2000 Act follow. Point 1. Point 2, in a similar vein, the respondent submitted that if a person spends more than £10,000, that person must be registered as a permitted participant. I emphasise the word spends. The legislation doesn't use the word spend or any cognate form. It doesn't use the word pay or any cognate form. It is concerned with expenses incurred by or on behalf of an individual or body. That is the phrase which is repeatedly used. And what section 117.1 tells us is that if the total referendum, tells us that the total referendum expenses incurred by or on behalf of an individual must not exceed £10,000 unless that individual or body is a permitted participant. Third point, the learned friend submits that the Electoral Commission's reading of the provision, quotes, blows a hole in the policy behind the limits set by the 2000 Act on different classes of permitted participants. She says that the hole gets blown in the policy by a person or body paying for services in order to help a permitted participant. And what is wholly omitted from her analysis is that Parliament has dealt with this. It has specifically addressed the issue by setting out a carefully calibrated regime which it calls common plan expenses. But it's worse than that, the analysis of the respondent, because not only does the respondent ignore that the whole doesn't exist, the respondent is indifferent to the effect that the addition of an extended definition of expenses incurred has on the regime that Parliament has created to deal with common plan expenses. Because if we look at that, and my friend was keen to avoid looking at the 2015 Act as if it didn't exist, turn the
I think that's perhaps unfair, Mr. Coppell, but let's stick with the submissions.
page 186. Paragraph 22, subparagraph 3. What it does is it makes the common plan expenses treated, except in the case of a designated organisation, as having been incurred by both the paying body, the incurring body, and the non-incurring body. So that empties out the need for the reading that the respondent would have court believe is correct.
You say that, but Ms. Seymour submits that this was enacted in 2015 and the 2000 Act must be construed without reference to this addition.
That's simply incorrect. We are concerned with the 2016 referendum.
Yes, but
The two have to be read together.
well, that's right. But you want guidance, apparently, more generally about the 2000 Act. The 2015 Act won't be relevant if it's an alternative vote referendum or something else in the future.
As I indicated at the outset, the 2000 Act sits there as a generality. And for each referendum that you have, whether it's the EU referendum or whether you look at the alternative vote referendum, you will find a statute of similar complexity. In fact, the one for the alternative vote was longer.
You may be right. You may be right. It may or may not in the future contain a common plan expenses set of provisions. But the fundamental point Ms. Seymour makes is that the 2000 Act imposes limits on the expenditure, not limits on donations. And she submits that what the Divisional Court said was absolutely right, that the underlying legislative policy is not to allow for easy circumvention of those spending limits.
And that issue has been specifically dealt with by Parliament for the purposes of the EU referendum in these provisions. And the two acts must be read together, not, I say, in isolation. So I understand the way it was put, and I understand why it was put the way that it was put. And I say that that is an impermissible approach. We are concerned with the EU referendum. We are concerned with reading the provisions together. And if we want to go and traipse through in relation to other referendums that have been held under the 2000 Act, we will find a whole body of provisions that address it. And what Parliament is doing is it's saying, well, in relation to a specific referendum, we are going to deal with it in a particular way, common plan expenses. And one of the reasons for that is, fine, in relation to the 2016 referendum, there was a choice of between two, but it contemplates that sometimes you can have 3 choices, or you can have 4 choices, or you can have tiered choices, you can have preferential voting in referendums and all the rest of it. And so in relation to that, the technique which is adopted by the 2000 Act is to say, here's the general machinery, we have got a specific referendum, I'm going to adjust that to deal with the particular referendum in questions. And that's what's been done here. And that's why I say it is not permissible to look at the 2000 Act provisions in isolation from the bespoke amendments and adjustments that were made in respect of the 2016 referendum by the 2015 Act. The point that I make, I wanted to come to, it's paragraph 5 of subparagraph 5 of paragraph 22, because
I'm sorry, which page are you on?
page 187. Because what the construction of the respondent would do would be to render this ineffective. It renders it ineffective because what subparagraph 5 does is it says if you have as one of the parties to the common plan expense the designated organisation, only the designated organisation is to report that, not the other party. So to illustrate my point, we have in my example A is a permitted participant, but it's not a designated organisation. B is also a permitted participant seeking the same outcome, and is also not a designated organisation. A and B have a plan, common plan to share expenses. Pursuant to the plan, B incurs an expense of £100,000 and pays that. That is a situation under subparagraph 3, both of them must record it, as well as in their declarations, not just in their declaration but also as an expense. Now I'll change the facts a little bit, and here we're going to say same facts generally, except A is a designated organisation. Same facts, B makes the payment, but subparagraph 5 tells us only A is to record that payment. And the reading that the divisional court would give, and that's urged upon you by the respondent, is say, forget all of that, don't worry about this regime, they have got to record it. A has got to record it. And I say that is in defiance of subparagraph 5. Fourth point is, as for going through the emails, the various internal documents of the Electoral Commission and the assessment reviews and so on and so forth, they are irrelevant. This appeal proceeds on the facts, the assumed facts, which the Divisional Court set out succinctly in paragraphs 12 to 20. It's on those facts that the Divisional Court reached its conclusions, and it's on those facts that this appeal is referable. And finally, I've not heard, I don't believe this court has heard, any reason why it is necessary to extend the reach of the phrase expenses incurred on behalf of a body or individual. To extend that phrase by adding to it what we see in the Divisional Court judgment, the final sentence of paragraph 77. That's the phrase where A transfers money to B in performance of such an obligation. The nexus between A's spending and the goods or services purchased is of such strength as to require the treating of expenses incurred by A as A's quota. No reason why that, together with the gloss with reference to quis close trusts and all the rest of it, 78, 79, there's no reason why that needs to be added to the reach of the phrase.
Isn't it the reason they gave, forgive me,
I'm sorry.
isn't it the reason the Divisional Court gave at the very end of its judgment, which was to give effect to the statutory policy of imposing spending limits?
Understand that.
So
But as
£10,000, for example, for the ordinary individual. If you're right, what Ms Seymour says is that could be blown away by somebody paying in these sorts of circumstances indirectly.
Look, it's always going to turn on, we say, buyer on behalf of, so it can get captured that way, or it can be a common plan expense. But if it's not buyer on behalf of, it's not by the person, and if it's not within the common plan expenses, it is the decision of Parliament that it is outside the limits.
No,
And it's not.
I was only quibbling with the suggestion that no reason has been given. I was suggesting that a reason has been given. We'll have to assess whether it's a good reason or a bad
Well,
reason.
we would say it's a thin
I see.
reason once you take out all of those
Thank you.
circumstances. So just bear with me, see if there are any further submissions from anyone behind. Nothing. I'm very grateful.
Well, thank you very much. Yes, Ms Simon.
In light of the note that's been handed up, which I haven't read in detail, but in light of the points that have been made about incurred, would you allow me to hand up the skeleton of this before the Divisional Court with a little tab? You don't have to read it all, but there are just the bits, if you do decide to deal with incur, there are our arguments on the question of incur, where the red tab is.
I'm sure that will be helpful.
That's it.
Thank you. I think Lord Justice Singh has one final
Yes,
question.
just a couple. Seymour made a submission based on Schedule 13, paragraph 2, on page 169 of the Authorities Fund. Do you have page 169?
Yeah.
Thank you. And it's to do with the exclusions in paragraph 2. And if I understood her correctly, Ms Seymour made the submission, which is a point the Divisional Court also made, that the provisions of paragraph 2, little c, provide some statutory indication that where those circumstances don't apply, then the implication is that it would constitute expenses incurred, because it excludes it where you're not reimbursing the person. So the implication, they said, and she submits, is that if you do reimburse someone, that is expenses incurred by you.
No, what we've got is it is, in a sense, setting the bounds of what's in paragraph 1, and it's refining those bounds. So all it's saying is that nothing in paragraph 1 shall be taken to extend to. So you look at the normal meaning of each of the list of each of the items in the list of matters 1 to 8, and then it is confining those so that they aren't treated as they aren't treated as being incurred for referendum purposes. But that's all that does. It doesn't prove what is sought to be proven, and indeed it can be characterised as really being no more than taking it as a matter to remove any doubt as to the point, I suppose is the best way of putting it.
Thank you.
Yes. Well, we're very grateful to all of you, Mr Coppell, Miss Seymour, and those who've been assisting you for your submissions. You've given us a lot to think about. We will, of course, take time to consider our judgments. We will circulate drafts in the usual way and invite corrections from counsel. I emphasise corrections, not an opportunity to re-argue the case. We would invite the parties to try to agree an appropriate order consequent upon whatever our judgments contain. To the extent that there are any matters that can't be agreed or there are any consequential matters that need to be dealt with by the court, we will consider those on written submissions. When the time comes to hand the judgments down, there will be no need for anyone to attend. Thank you all very much.
Court rise.